Good day, Crime Talk aficionados. It's Saturday. What does that mean? That's right, the weekly recap of all the top stories throughout the week, all conveniently located in one location. Hope you enjoy the recap. We'll see you next time on Crime Talk. All right, let's get to it today. Letecia Stauch. You remember Letecia Stauch. This case seems like it is just drug on and on and on. Well, I think it's going to continue to drag on. The defense has filed some motions. They filed motions. They were due December 28th. All right. What did the motions indicate that we can learn from this case by the motions filed? Well, the first one that the defense filed was a request that Letecia Stauch not have to come to the next court hearing. Now, the defense attorneys have communicated with Ms. Stauch, and it is her desire to not appear in person at the hearing due to her mental health and stress that an in-court appearance will place on such. That's their words, not mine. Now, defense counsel is prepared to proceed to hearing without the presence of the defendant, and they do note that the chief judge down there in El Paso County canceled all of the jury trials as of January 3rd because of the continuing COVID-19 pandemic. The counsel also notes in their filings that many of the wards at the El Paso County Jail are currently quarantined, and many of the in-custody defendants are not being transported because of the rapid spread of the Omicron variant. Now, what's interesting about that? Really, Letecia Stauch doesn't want to go to court because it basically stresses her out and it affects her mental health. Well, Ms. Stauch, and the attorneys got to do what they got to do. They're doing what they can for their client. But guess what? You're charged with first-degree murder. It's supposed to be stressful. That's part of the harassment package, so to speak. It's part of the justice process. And I don't know what the judge will do. Frankly, if I was the judge, I would have her show up in court so there's no issues down the road as to whether this was a knowing voluntary waiver. And if the court is even considering it, the court should conduct that colloquy, that engagement conversation with Ms. Stauch in person, on the record, making sure she wasn't going to be able to come back later and say, I didn't understand. Additionally, the defendant needs to be there for trial. The only way a defendant is usually excused from their own trial is if they are disruptive during that trial. But Ms. Letecia Stauch, she needs to go to court, okay? Bottom line, that's just the way it is. So what other motions did the defense file in this case? Well, they filed a motion to suppress the search of the Apple iPhone 8, a motion to suppress the ADT security system, a motion to change venue, and a motion for expert discovery. And there's also a motion to suppress wiretaps. That's right. They tapped Letecia Stauch's phone because, well, lack of communications. So let me explain wiretaps, ladies and gentlemen. It used to be really difficult for the government to get a wiretap, right? You actually had to go plug in buttons and do all this crazy stuff at the phone connection center to do a wiretap. It was frankly quite complicated. Now the only thing that's really complicated about getting a wiretap these days is the amount of paperwork that is required that is usually cut and paste from another case, and they throw in some facts. Now, what do they have to show in a wiretap application? The government has to show that basically all normal investigative techniques have failed, and therefore the only thing that we could possibly do was to tap somebody's phone so that we could listen to the call. Now, usually the wiretap application is about 50 pages long, and they have to give you all this information saying this is the facts of the case, and judge, we just can't get it, but we know if we were able to listen in on these calls that we'd be able to do it. Now, how do you suppress a wiretap investigation and an actual wiretap so that none of the wiretaps could be used against you? Well, in this particular case, you have to say that there's no probable cause. Like, hey, there's no crime being committed. kind of a weak argument, and it's pretty weak in this affidavit. And I'm not trying to criticize these motions, but we challenge wiretaps pretty regularly, and I got a pretty good motions guy, and this looks a little boilerplate. That's all I'm saying. I think it's a little boilerplate. But then they have to show that that these normal investigative techniques would fail. Well, what are new normal investigative techniques? Well, basically, you couldn't put an undercover officer in to talk with somebody in this particular case. Now, but you still have to articulate the reasons why you wouldn't be able to do that. And here the defense says Detective Bethel, Bethel, fails to provide any facts to back up this belief, where he says that no agent could possibly get close enough to Miss Stauch in any way. Well, I don't know why they just don't go over, maybe buy her dinner. It worked in the Barry Morphew case. You remember that? They just kept going over, asking him. Next thing you know, he's inviting him over for dinner. Could have tried that, I guess. In this particular case, the defense then says, well, there wasn't a whole lot of forensic testing of physical evidence. And their motion states that the affidavit talks of the use of forensic testing of physical evidence and admits that the evidence has been collected and sent off for testing. The affidavit then states that the tests take time, but fails to elaborate on the specific test or possible time parameters. Kind of weak arguments. Interviews and grand jury. Well, Detective Bethel admits that these close friends and associates of Miss Stauch could potentially be successful in achieving the goals of the investigation, and this statement flies in the face of the necessity requirements, right? You're going to the court to get a wiretap by a court to listen to your deepest, darkest conversations, right? You have a general expectation of privacy that when you're talking on the phone that nobody's listening. So it's very invasive to do that. And I mean, this is neither a case where, frankly, lack of cooperation, but I mean, it's a criminal investigation. The defendant has a right not to testify. She moves out of state because she wasn't under arrest. They think they could talk to her friends, but they're not going to do it. Pretty weak case, in all honesty, for a wiretap. Now, I don't know what evidence they got from the wiretap because, well, they don't really outline that in the motion, which is kind of why it's kind of weak, because usually you want to tell the judge what evidence was obtained shouldn't be considered, not just all of it, unless you're just saying it fails for probable cause, which I guess is what they're saying here, but it's still kind of weak. The next motion, a change of venue. Now, I just drafted one of these change of venue motions, and you need to put a lot of information in there. You can't just basically say, hey, there's been a lot of pre-trial publicity. You have to basically give a lot of statistics. What's the population in El Paso County? What is the subscription of the local newspaper down there? What is the potential jury pool? You have to put some real work into these types of things by calling the jury commissioner, collecting each and every newspaper article to show that somehow there's going to be so much publicity that, judge, now you should have to do this and grant a motion for change of venue. And let me tell you one more thing. This motion should have been filed months and months ago, because per statute, it is, or per the rule, you have to move for motions for change of venue at arraignment, or you have to show good cause. Normally, judges will let you get by with it, and I'm telling you, I've only had one change of venue ever granted early on. Normally what happens is you wait and see, and it takes place in smaller communities. You wait and see whether there is a problem getting potential jurors in the case that haven't heard about it or formed an opinion. In a larger jurisdiction like El Paso County there in Colorado, pretty big jurisdiction, I'm sure you're going to find people that haven't heard about Letecia Stauch in any way whatsoever. Now, the warrant to suppress the affidavit as it relates to the search warrant from ADT, this is attacking a general warrant, okay? What does that mean? Under the Fourth Amendment, let's pull out our handy dandy Fourth Amendment. Fourth Amendment clearly states the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall means mandatory, not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons to be seized. The warrant that was searched in the ADT matter, in the application for a search warrant, well, This is a general search warrant. It basically says, hey, I'm a police officer, and I would like to believe that there is material evidence of a subsequent criminal prosecution required or permitted by statute. That's it. And it basically just says, I want to search ADT. He states in the affidavit that during the subsequent 40-hour period, Ms. Stauch refused to meet with the sheriff's office or provide the requested information regarding her stepson. She doesn't have to. At that point, she's subject to an investigation. And so it goes through the application, pretty generic, and basically it says Ms. Stauch said she left the house and went shopping and came home at approximately 14:30 hours, which is 2:30 p.m., and Ms. Stauch disarmed her ADT security system upon entering the house and went downstairs. While downstairs, she met with an unknown man who pointed a handgun at her. The man allowed her to go upstairs to greet her stepdaughter, Laina, L-A-I-N-A. Laina. Ms. Stauch said she sent Laina outside to ride her bike. Then it says the Stauch residence is protected with an ADT system, and that records entrance. The document goes on. The affidavit for the search warrant says that the Stauch residence is protected with an ADT system that records entrances and exits from the home. The system also contains information on when it is armed in stay or away mode. Ms. Stauch reported disarming the system and placing it in the stay mode. Now, what's interesting is that is a very generic application, and in there they basically said they want all the account information, any audio or video, any log history, any activation or deactivation, passcodes assigned to a particular date. You know how this could potentially fail is that they weren't specific as it relates to the date that they're seeking. Although they give a general background in the attachment saying, January 27th, January 28th, they don't actually ask for that in the attachment, which is all the things specifically requested. The defense may have an argument here. Now, whether a judge will throw that out, I don't know. Like I said, you have to be specific. When a government agent says, we're going to look for something, they have to say, we're going to look for a specific thing that we know we're going to find it. That's why phone searches get thrown out pretty regularly, because they say, we're just going to search the phone. We're going to go rummage around in there until we find what we're looking for. You can't do that. You have to be specific. We want a text message between this person and this person on a specific date. You don't get to go rummage and say, we know it when we see it. That's exactly what the Fourth Amendment provides against. We'll see what happens there as well. That is the same argument that the defense makes as it relates to the search of Miss Letecia Stauch's cell phone. You have to be very specific in the application of what you're going to seize. And I'll be honest with you, this is about the time period where law enforcement here in Colorado was screwing up their affidavits, basically saying, let me search the phone. Judges were rubber stamping it. And the Colorado Supreme Court said, you can't do that. That's a general search. Guess what? Case goes away. Guess what happens when it's a general warrant? Everything from that phone could be suppressed. What does suppress means? It means the prosecution cannot use it in its case in chief. Could be potentially bad for the prosecution in this particular case. We will see if the prosecution bothers with filing a written response. So many times the prosecution does not file written responses. I don't understand that. You have to ask for it these days, or you have to go to federal court where it's expected that the prosecution file a written response. We'll watch how the court deals with the motions hearing. The motions in this particular case are to be heard on January 13th. Unfortunately, we can't bring it to you live, but we will be watching for sure. All right. Maybe now it's finally getting interesting, because this case goes back a long way, ladies and gentlemen. The prosecution wants to cut a deal with Ghislaine Maxwell. All right. So some court filings released today show that the prosecutors are willing to drop the 2 charges of perjury against Ghislaine Maxwell if a conviction for sex trafficking is allowed to stand. 60-year-old Ghislaine Maxwell is due to be sentenced at a later date to be determined, but as of right now, there's an ongoing disagreement over the timeline. Prosecutors want Maxwell sentenced within 3 to 4 months, but her defense team has opposed setting a sentencing date, arguing that there is a compelling basis to overturn the conviction. As you may recall, her lawyers last week demanded a new trial after a juror revealed he had helped convict Maxwell by telling fellow jury members about his own experience as a victim of sexual abuse. That's right, ladies and gentlemen, you can't do that. Wrong. Really, really wrong. Well, the U.S. government has now offered to drop the 2 perjury charges linked to claims that Maxwell made in a 2016 deposition in a separate civil lawsuit should the sex crime conviction stand. Now, each perjury charge carries a maximum of 5 years in prison, and the charges allege the convicted sex trafficker lied under oath by hiding her participation in that guy named Jeff's offenses during a separate civil case brought against her by Prince Andrew's accuser, Virginia Jeffrey. Now, confirming their position in the letter to the judge, the United States attorney said, quote, "In the event that the defendant's post-trial motions are denied, the government is prepared to dismiss these severed perjury counts at the time of sentencing in light of the victim's significant interest in bringing closure to this matter and avoiding trauma of testifying yet again." Oh, I'm sure that's the case. Now, if any of the defendant's post-trial motions are granted, the government proposes that the parties be directed to promptly confer and propose schedules for the further proceedings. That schedule may depend on the manner in which the court resolves the motions for the new trial. Prosecutors are also requesting the preparation of a pre-sentence investigation report, but the defense is arguing that Maxwell shouldn't have to do that until and if there is a retrial and if she is convicted. So let's talk about this, ladies and gentlemen. First, if I was the defense, I would tell the government to go politely pound sand. Ooh, you're going to dismiss a couple of perjury charges, a charge that rarely, if ever, gets prosecuted in court, let alone federal court. That was a tag along and really has no relevance whatsoever as it relates to the case of Ghislaine Maxwell. Sure, they're charges, but whatever, okay? Those charges are certainly not Ghislaine Maxwell's biggest concern, I assure you not. Now, the court, and I hate to say this, the court should grant Ghislaine Maxwell a new trial. The juror that came forward and actually told the press that he explained how he remembers things and talks about his experience as a sex crime victim, guess what? That's wrong. That means he didn't go into the trial as a fair and impartial juror willing to reserve judgment after listening to all the evidence and then follow the court's instructions. It is becoming rather clear that not one, not two, but now up to 3 jurors may have lied on their juror questionnaires by not revealing information that was plainly and straightforwardly asked of each and every individual that was going to be on that jury. And when jurors don't answer truthfully, guess what? They are no better than the individuals sitting over there at the table with the nameplate that says defendant in front of them. So the bottom line is the defense needs to tell the government to go pound sand. The judge needs to grant Ghislaine Maxwell a new trial. The juror needs to be held in contempt, possibly thrown in jail, and should, as a sanction, have to pay for the attorney's fees and costs associated with the defense and the prosecution having to come back and do that trial over again. The question now becomes, will the court have the guts to do the right thing? This is simple litigation 101. When you find out jurors have lied, or they bring in extrinsic material to a courtroom in their deliberations other than what was legal and competently presented evidence that was admitted into evidence, it's a do-over. It is a do-over, and the government needs to confess the motion for a new trial. The judge needs to grant it. Whether you are a fan of Ghislaine Maxwell, and I doubt there are very few fans of Ghislaine Maxwell, or you think that she is the biggest scum of the earth, the bottom line is she deserved a fair trial. And imagine, ladies and gentlemen, if you or a family member was sitting in that courtroom at a table with a little name placard said defendant, that's right. You would want to make sure that those jurors were fair and impartial and didn't lie to get on that jury. And so therefore, new trial. Prince Andrew, wishing he had never met that guy named Jeff. That's right. Prince Andrew is under pressure to settle with Virginia Roberts Jeffrey after a New York judge refused to throw out her case. Now, the decision is kind of a big blow to the Duke of York, who now faces huge expensive fees and reputation-shredding court case next September unless he tries to pay off Miss Jeffrey with at least $5 million. Now, if Prince Andrew chooses not to settle or if Jeffrey rejects his offers, he faces being interviewed by her lawyer in a videotaped deposition in London that could be played in court. Now, although Andrew cannot be forced to give evidence because this is a civil suit in a different legal jurisdiction, well, guess what? He's going to have to participate. So far, Prince Andrew has been forced to sell off his $23 million Swiss chalet to cover his legal expenses because the Queen has reportedly refused to pay the bills. Good for her. Now, Judge Lewis Kaplan has slated the case to be held between September and December, with Andrew having the option to appear virtually. If Andrew decides to appeal today's decision, this timeline will likely be pushed back. Now, Andrew's attorneys had unsuccessfully argued that Jeffrey's case should have been thrown out because of the newly unsealed $500,000 settlement with that man named Jeff. Andrew's lawyer, Andrew Bretler, argued it protected the prince because it contained a clause where Jeffrey agreed not to take any legal action against potential defendants. Yeah. Well, Judge Kaplan said, for the reasons cited, defendant's motion to dismiss the complaint for a more definite statement is denied. Now, given the court's limited task of ruling on this motion, nothing in this opinion or previously in these proceedings properly may be construed as indicating a view with respect to the truth of the charges or countercharges or to the intention of the parties to enter into the 2009 agreement. Judge Kaplan said the court was not able at this stage to consider the Duke's efforts to cast doubt on Miss Jeffrey's claim or whether he was covered by the settlement agreement, suggesting these were all issues ultimately for trial. Now, Prince Charles, Meghan Markle, and Sarah, Duchess of York, could all be called as witnesses. Now, David Boyce, the lawyer representing Miss Jeffrey in her legal action, has claimed Andrew's daughter Beatrice could also be called because her father used her as an alibi, claiming that he was with her at a pizza joint on the night he is alleged to have slept with Miss Jeffrey. Now, understand, someone based in the UK cannot be forced to give evidence because it is a civil case in a different jurisdiction. If the trial does go ahead, Andrew would likely be subpoenaed to appear in person, but he could refuse to attend. He cannot be forced to attend any U.S. court because UK citizens cannot be extradited to America for civil matters. His deposition would be used in lieu of live testimony, but that would likely play out poorly in front of a jury. He will not be able to rely on diplomatic immunity to avoid the case because it only applies to the Queen and her immediate household. News was also released today that the Duke of York cannot return to royal duties because his reputation is damaged beyond repair following a decision to allow a civil case to be brought against him by Miss Jeffries. His mother, the Queen, has had a horrid year dealing with this mess, and it will continue unless her son settles to avoid a trial. Now, let's face it, the Duke had a very bad day. Probably not going to have any great days in between until this case is settled, and the mere fact that he may have to pay the money, you know, if I was the plaintiff's attorney, the price to settle probably just went up just to have the embarrassment factor for the Duke there, that's for sure. Now, will this case settle? Who knows exactly what it will do, but I assure you the Duke is probably trying to get this over with as quickly as possible, and he's probably going to have to write a big check with a lot of zeros. Now, Miss Jeffries, she settled for $500,000 with Mr. Jeff, that guy named Jeff, right? So I'm not exactly sure other than why inflation would be more for the Duke. Leading us back once again to the 12 undeniable truths from a criminal defense attorney. It's always about the money. Well, one thing I sure know I am happy about, and that's that I am not Prince Andrew. Granted, he had to sell his $23 million Swiss chalet to pay for legal fees. Well, things just got a little worse. Prince Andrew has officially been stripped of his military roles, royal patronage, and his HRH, his Royal Highness, by the Queen. Ouch. That's right. Ouch. When the Queen Mother and your mom say enough is enough, that's right. No TMM going on over there anymore. She has had enough. So the Queen Mother, the Queen, said that he will have to face his sexual allegations as a private citizen. This comes a day after a judge rejected the prince's bid to have his sexual assault case thrown out, leaving him facing the prospect of being cross-examined for 7 hours on camera with some, well, what could be perceived as embarrassing questions on everything from his sex life to descriptions of his private parts. Now, Andrew has been urged to settle out of court with his accuser, this Virginia Jeffrey, pronounced Jufrey, I guess, for the sake of his mother, who celebrates her platinum jubilee this year. But he could face difficulties given Miss Jeffrey is said to be pushing for her day in court. Of course she is. She is going to press this until he is so nervous and so scared to go up in court, and will cough up all of those $23 million from the Swiss chalet that he had to sell from all that hard work that he did of being a royal. Don't you just feel really sorry for the guy? Yeah, sure don't. Well, the palace also said that the Duke's military appointments were suspended after he stepped down from public duties in 2019. And prior to today, he still retained roles, including the position of Colonel of the Grenadier Guards, one of the oldest and most emblematic regiments in the British Army. More than 150 veterans joined forces to express their outrage, writing to the Queen to demand Andrew be removed from the honorary military positions. My goodness, I'd think to say Prince Andrew, Duke of Windsor, or whatever he is, guess what? You've been canceled. That's right. Seems like everybody that hung out with that guy, that's right, everyone that hung out with that guy really coming back to haunt him. Well, unless, of course, you're Bill Gates or former President Bill Clinton. No repercussions there. Just saying. First, the not-so-Prince Andrew. A source close to the Duke of York has said that the prince will continue to defend himself against the lawsuit in the United States. And as announced yesterday, the Duke of York will no longer be known as His Royal Highness and has been stripped of military patronages. Sources said, given the robustness with which Judge Kaplan greeted our arguments, we are unsurprised by the ruling. However, it was not a judgment on the merits of Miss Jeffrey's allegations. This is a marathon, not a sprint, and the Duke will continue to defend himself against these claims. Now, his accuser, Virginia Roberts Jeffrey, is said to be determined to snub any offer of cash in favor of her having her day in court. Now, Miss Jeffrey is suing the Duke in the U.S. for allegedly assaulting her when she was a teenager, 17 to be exact, claiming she was forced to have sex with him 3 times when she was 17. Now, Judge Lewis Kaplan dismissed a motion by the Duke's lawyer to have the lawsuit thrown out after they argued that Jeffrey had waived her right to pursue suit against the royal because she signed a settlement/confidentiality agreement that was with that guy named Jeff. Now, Miss Jeffrey wrote on her Twitter that she was pleased with the ruling, adding, "I'm glad I will have the chance to continue to expose the truth, and I'm deeply grateful to the extraordinary legal team." Well, let's talk about that, ladies and gentlemen. First, listen, all cases will more than likely be settled when it comes to the civil matters. We'll have to wait and see what happens. My guess is for a certain dollar amount, everybody could find a reason to settle. Just like the prince may have to face some embarrassing questions, so might the Miss Jeffrey herself. As to explain, How is it that your parents let you travel around the world when you're 17 with grown men, grown creepy old men? What kind of father allows that? But either way, she's already received some $500,000 from that guy named Jeff way back when, and it included that very inartfully drafted settlement agreement, basically saying anyone close to that guy named Jeff. Yeah, you need some specificity when you're drafting those settlement agreements, and they should have thrown some names in there, like, Ghislaine, Prince Andrew. Otherwise, it's really not worth the paper it's written on, as the prince has discovered this week by the court's ruling. Really not surprised. Just like in a criminal case, where at a preliminary hearing, the evidence needs to be viewed in the light most favorable to the prosecution, drawing all inferences in their favor. Same thing in a civil suit. The civil suit may be completely bogus, but the court has to follow the law, and the court has to look at the allegations as true, basically giving all deference and inferences to the plaintiffs to prove their case. It may turn out to be completely false, but you have to go through the process. We'll obviously continue to follow the Prince Andrew matter because it's got to get really good. And Miss Jeffrey has some very expensive attorneys. David Boyce, one of the most powerful attorneys in the country, is prosecuting that case on her behalf. I don't know if it's a contingency fee basis. I'm assuming it is, but the guy probably charges $1,000 to $2,000 an hour, maybe probably $5,000 an hour. He is a pretty smart guy. We'll see if he can get a victory for Miss Jeffrey. All right, that's all we have for you today. Thanks for watching. We'll see you next time on Crime Talk.